Back at it again, here to make a formal complaint with case law and everything.
What happens is he can either call legal aid or, I'm sorry, one
Yes,
second.
okay. I need to speak to the supervisor about a very, very important issue regarding my representation.
Okay, who's your lawyer?
Rebecca Gregory. Well, she's not anymore, but she was. Okay, do I need to sit or?
Give me 1 second. What's your last name? First name? Date of birth. Come on, what's my birthday?
Aries. You know we rule the world, right?
Of course.
Yeah.
All right. You had court on the 10th.
Mm-hmm.
All right. Let me just write this down. All right. I'm going to email her supervisors.
Okay. Is there any supervisor here now that I can speak to?
I'm gonna find out for you.
Thank you.
I don't know exactly who's here.
Okay.
She has 2 supervisors,
Mm-hmm.
so I'm gonna email both of them and see who replies back to me.
Thank you.
Okay.
Thank you.
Well, how can I help you?
Yeah, so I was arrested on the 5th of March of this year. I was the victim of assault. I was a victim of harassment. I was a victim of coercion and menacing on a Q train by a Manhattan District Attorney paralegal.
Yes, I'm actually familiar with your case.
Yes. So I didn't bring it on me. I faulted by not bringing the actual felony complaint and the indictment. But in that incident, the NYPD hesitated on arresting the assailant or the man that was harming me. And that actually stole my phone from me. He smacked my phone from my hand and dropped my phone. He put it in his pocket. So that's robbery in the 2nd degree. I had 2 witnesses come off the train and corroborate at least that fact. He did way more than just steal my phone, but they at least corroborated the fact that they saw that he smacked my phone from my hand, picked it up, and put it in his pocket. The NYPD hesitated in arresting him. I had to reiterate time and time again the fact that I'm making a claim of assault, and by law you must arrest him. And I looked down and I saw that the man actually had scathed my skin a little bit, and I said, "Hey, look, I have an injury. Now you must arrest him because I have a visible injury." So the lady went over to him. No, she said first to me that okay, I have to arrest him now because she only wanted to file a harassment report, and at that time she was filing a harassment report for me. So that means that the 2 complainants had no charges against me at the time. Because if they're only going to file a harassment report for me against them, that means that I would have walked away a free man after that harassment report was filed. He said, okay, I have to go arrest him. Went over. The man fell down on the floor and acted as if I had harmed him, even though we were standing at that one place for longer than 40 minutes with no complaints, as I told you, no complaints, just a harassment report on my end. So she came back to me and said, I have to arrest you too, because the man's claiming that you hit him in the head with your cell phone. That's outside of probable cause, because a reasonably prudent person would not believe that man after 30 minutes, after no complaints of me harming them, nothing, for them to now come to me and say he's claiming on the spot that I hit him after I had to plead and plead and plead. I don't know if it was a racial thing.
I don't mean to cut you short, but I know that we no
Yeah,
longer
you know
represent you. So
yeah, no.
I'm just asking, how can I assist you?
I'm gonna, because, all right, so you know the story. I didn't know how well you knew the story. So based on the facts that I just told you, there was a insufficient felony complaint drafted. I knew that. Rebecca Gregory confirmed that, and my lawyer, or the lawyer that's on my Manhattan case, confirmed it as well, that the complaint on its face is completely insufficient and defective because none of the charges were made out by the factual portion of the complaint. But yet and still, at first arraignment, Ms. Gregory only argued one of the charges, which was obstruction of governmental administration. She argued that that was insufficient, when in fact all of the charges were insufficient. And upon further research, I realized that, LexisNexis in jail, the kiosk, I realized that an argument to dismiss the felony complaint due to insufficiency can be made at first arraignment. Once I bailed out, I asked Rebecca Gregory why she didn't argue the dismissal of the complaint, and she said to me, quote unquote, "We don't do it that way."
Okay.
So now, with her not doing it that way, that allowed the court to continue on its presumed probable cause, which should have been checked at the precinct by the sergeant before that complaint was sent off to the DA, and then that should have been checked by the judge as well to stamp off on a probable cause for the complaint to even get to arraignment. So it was faulty all the way through, and Rebecca Gregory admitted this, that all of the charges on the complaint was not made out. But like I told you, she said we don't do that on first arraignment, even though it should have been done at first arraignment, to not have me go through the hardship, the heartache, the pain, the fear, the trauma of potentially going back to jail, an indictment, a grand jury proceeding, and all the things that transpire after that. So I would like to speak to someone, I guess, of higher authority regarding the representation and what can be done to remedy it. I know she's not on the case anymore, but I asked her to stay on the case. And she, me presenting these issues to her, she was the one that said, well, why don't you just release me? I said, no, because 1 or 2 issues doesn't amount to ineffective assistance of counsel. It's a broad range of issues that have to amount to that. So before you leave and run out the exit door, I'd like for us to repair this and for you to assist me properly, given the new circumstances and the new cases and case law that I had waiting for her. But the court allowed her to be removed. I don't know if it was permissive or mandatory, but they just allowed her to be off the case. But as I said, there was many issues regarding the complaint and it going forward, which it should not have.
I'm not quite sure what it is, because on one hand you are addressing the issues with the complaints, and it seems to me your unhappiness with the way that Ms. Gregory handled your case. That's one issue, if I understand you correctly. And then the other issue is that you wanted her to stay on your case.
I wanted her to stay on
So
because she knew the case wholeheartedly.
Those two don't really mesh, though, right? Because if you're saying that your attorney has done something wrong, and especially if you're saying that your attorney has done something wrong at a crucial stage in the proceeding, which your criminal court arraignment is a pretty crucial stage in a proceeding.
It's not. It's stated that it's not in the law.
Well, it depends on what you're arguing in the law. So it is a crucial stage in the proceeding, which is why you're entitled to an attorney. You're entitled to an attorney, and you are entitled to be present in the courtroom.
But not
it's
mandatory.
A crucial stage.
Not mandatory. A lawyer is not mandatory at that stage. So it's.
But you're entitled to an attorney. So it's a crucial stage of the proceeding. You've expressed unhappiness with her.
Handling certain
representation at that point, and I'm aware that you have expressed unhappiness with other areas of her representation
regarding an evidence DVD that she told me was faulty due to her IT guy making a technical mistake when burning a simple DVD, and that video wasn't able to be played at grand jury. So those maybe 2 or 3 issues, but nothing that couldn't be repaired.
But at this point, Brooklyn Defender Services, Ms. Gregory has already been relieved of your case.
Sure.
So, at this point, my understanding is you have been assigned an attorney by the 18B panel.
I believe, yeah.
So, I think you should go forward with that attorney. I'm not familiar with who that attorney is.
See, but then now the thing is, at the last court date, a plea of not guilty was entered on my behalf. And at the court date before that, I actually halted the court in arraigning me due to me challenging its subject matter and personal jurisdiction regarding the faulty felony complaint. But at the next court date, which just passed on the 10th, I believe, she was relieved, another lawyer came in, and another one, so I'm on the third now. And a guilty plea was entered. So the thing is, what I'm trying to, a not guilty plea was entered. So the thing is, what I'm trying to say is, I know you're trying to get to the point of, I'm complaining about her, so I might as well have had another attorney assigned. But as I told you, regarding ineffective assistance, which I believe you're hinting at, it doesn't take one or two or three issues.
Well, no, I want to be clear. I'm not hinting at that. I don't believe that she was ineffective in any way.
Oh, okay.
I'm saying that it was your complaints. I don't believe that Ms. Gregory was ineffective in any manner in her handling of your case at all.
So if a lawyer here says that a client of theirs felony complaint is facially insufficient, every single charge, but then doesn't argue that at arraignment, how does that work?
I don't believe that it's up to the attorney to make the decisions on what he or she is what legal arguments the attorney is going to argue. So there are certain things that you as the client get to make decisions on, whether or not you would testify at trial, whether or not you would testify at various stages in your proceeding. There are some things that you absolutely have the authority to make decisions on. And then there are other things legal decisions that the attorney has the ultimate decision-making powers on.
Like going forward on an insufficient felony complaint.
Well, not going forward, because she's not going forward. It's the district attorney's office that would be going forward.
No, meaning that she didn't argue the dismissal of it once she knew, and she did know. By reading it on its face, her being a professional, before she even saw me in the pens at the bookings.
I can't address what she did on that particular day. I wasn't there, and Ms. Gregory is not here to tell me what she did. But if you're asking me...
Is she here?
She's in court right now.
Okay.
You're asking me what, in a specific incident, I'm saying that specific incidents, attorneys get to make legal calls, and clients get to make some calls.
Only if it's professionally recognized by everyone else in their field, and going forward on an insufficient, completely, totally, facially insufficient felony complaint. Any professional in the legal field would understand that that's an argument regarding jurisdiction, and if the court has no jurisdiction, the case is dismissed. Okay. It's 1, 2, 3.
So now we're back to the beginning again. So your position, if I understand you correctly,
yes,
is that what Ms. Gregory did, and I don't agree with this, but your position is that what she did was ineffective.
No, I said there was issues.
Okay.
There's issues that I wish she would have addressed.
It seems I'm still not clear
on
how I can help you.
Okay, so how you can help me? There's a private investigator that she had contact one of the witnesses that I had, defense witnesses. That phone call was recorded, and within that phone call, the witness states that they never saw me hit anyone during the entire time that they was on the train with me regarding the incident. So I would like a copy of that audio, and I had sent Rebecca Gregory a email stating such, and she said that she would transfer that to the new attorney on the case. That is not something that I would like, because one, I'm asking her for it, and there's no bar or procedural bar to her sending me the file, because I want the file.
Well, it's not a private attorney. Not a private investigator. It's an investigator who works for Brooklyn Defender Services.
Investigator, yes.
So it's work product from your attorney. So we're not going to give that to you. We're not going to hand that over to you. Brooklyn Defender Services will hand it over to your next attorney, but it's work product from your attorney. So she will...
but that's evidence in my case, and I have a right to get a copy of every piece of evidence in my case.
It's work product by your attorney.
But also evidence as well that will be used at trial.
And she's not saying that she won't give it to your attorney, but she's saying that she will give it to she'll give it to your attorney who's been assigned to you. And she doesn't have a problem with doing that as of right now. And I believe that's what she's told you. So that's what we will do. At Brooklyn Defender Services, we will turn it over to the attorney that is now representing you.
Okay, and also there's another issue. A Parker warning was issued at 2 court dates ago. I refused to sign, and I believe she signed a copy of the paper. Her acting as my agent and me stating that I'm not signing for legal reasons, would you say that that's another thing that she can do behind my back and sign a contract as my agent and then now making me liable for whatever she signs?
Well, it wasn't, if I understand correctly, and again, I wasn't there and she's not here, so I'm only going by what you're saying to me. It wasn't behind your back because you were there, right?
Yeah, but I said that I wasn't signing it.
Okay, but it was an open court and the judge gave you Parker warnings just telling you that you need to come back to court and they can proceed without you should you choose to absent yourself from the proceedings.
Sure.
So I don't know whether or not she signed the Parker warnings or not, but it would not be entering a contract on your behalf. It would just be that she was present in court when the Parker warnings were received. Not that she was accepting anything on your behalf, but that she was present in court.
Is there a way for me to get a copy of the case file that's held here at this office?
You can, yeah, but she's given you all of it. My understanding is she's given you all of her paperwork.
Oh no, I don't believe I have all.
I can only state what she's told me that she's given you. She told me that she's given you your file.
Can I have another?
I'll tell her to send you a copy.
Can I get it now since I'm here?
No, because she's in court right now.
Who's the case file held by?
She'd have to get it from, your case is closed, so she'd have to get it from the file room.
Can anyone do that?
Anyone can, but
Please.
she's the attorney, so I will wait until she comes back from court and she'll retrieve it.
So what could harm her legally by you giving me a copy of the case file?
Nothing could harm her legally, but
so
I'm
why
not doing it. She's the attorney. So if you want the file, you can wait until she comes back from court. She's told me that she's giving you a copy. So if you want, you can wait till she comes back from court, or she can mail you a copy.
Yeah, because this is a few days ago, so I'm pretty sure that there may have been an update regarding the last court date in the case file, so that's why I wanted the updated version.
Okay. The updated version would be that Brooklyn Defender Services would be relieved.
Yeah, whatever paperwork transpired from that day.
Okay, there shouldn't be any, I'm just telling you, there shouldn't be any paperwork when I represent someone and I'm relieved on a case. It's just, I write on the file Brooklyn Defender Services relieved, and I write the name of the attorney who the case has been assigned to.
Okay.
But, you know, you're more than welcome to wait until she comes back from court. I'll inform her that you're here and get a copy of the court papers.
Okay, thank you for your time so far. I just have one more question, if you could oblige me. I'm really having a very big issue with this case being converted from the arrestable stage to the indictment stage. And as I said, it was based on an insufficient felony complaint. I wish I had a copy to show you so you could then be more inclined to give me a professional answer, because you said that, you know, she's the one that dealt with it and you don't have it in front of you. But
if I understand correctly, you testified in the grand jury, right?
I did.
So you were indicted. I understand you're talking about
Perjury.
I understand that you're talking about the original complaint. And so you were indicted solely on perjury? Is that the only?
Yeah, because everything, I have video that showed exactly what
happened. So you're saying they perjured themselves, the complaining witnesses?
They did.
But what were you indicted on?
All the charges, first degree coercion, second degree coercion, harassment, menacing, and another count of second degree coercion.
So again, you now have an attorney who you did testify in the grand jury, and you have an attorney who can either, if you are going to plan on going to trial with the matter, can either choose to, in writing, if he or she does not believe that legally the district attorney's office has any factual basis any legal basis rather, for sustaining those charges, that attorney can, if they choose to do so, write a motion to the judge as to why those charges should be dismissed, and then it's up to the judge if the judge wants to do that. And if the judge does that, then obviously if all charges are dismissed, then all charges are dismissed. If the judge then dismisses some but not all, then you would be left with the charges going forward with trial.
Of course. Is it practice here at Brooklyn Defender Services to allow a client's criminal prosecution to go forward based on an insufficient felony complaint?
No, of course not. I mean,
So
but you're the one who's saying it's an insufficient felony
No,
complaint.
she said it as well.
But
She said it as well.
Again, she's not here, and Ms. Gregory, in my opinion, is an excellent attorney.
If you could could you pull the felony complaint to just verify what I'm saying at the moment, so we can have a better understanding of this conversation, because that's the place where we have to disconnect.
But with all due respect, we don't represent you anymore, so I'm going to leave it into the hands of the attorney who represents you now.
Okay,
that seems to be the proper thing to do.
You did say you don't find anything wrong with her representation, but you will find out from her, and when you pull the record, the felony complaint, that it was insufficient on its face. So hopefully, if I come back and I speak to you again, you'll have a changed opinion regarding her representation, because no lawyer would professionally, with sound mind and with prudent judgment, make a client go forward and get indicted on insufficient felony complaint. So I just really want to clear that away with someone here, because it's messing up my life very, very badly, especially if the charges are false. And this is actually being my 13th false arrest in 4 years, because I'm an activist online and I have a voice where a lot of like celebrities are now paying attention to everything that I'm saying. So from me being an activist this way, the NYPD has been targeting me and not arresting assailants or people that harm me, but arresting me as if I committed the crime. Even if I have proof, they always delete my videos. They say I punched an elderly white woman at City Hall on the block of Mayor Bill de Blasio's office, where Argus camera was directly above me, and 4 more on the entire block, cameras on the mayor's grounds, but they say that all the cameras were inoperable that day. So I'm being targeted, and now with Rebecca Gregory going forward and not allowing the court to understand that it needs to dismiss the felony complaint, it just harms me very, very much. So I appreciate your time.
Again, I'm sorry. I'm sorry that you're going through this. And from my, I think that Ms. Gregory is an excellent attorney. I'm sorry that you've not experienced this before. And, do you want me to tell her to make a copy of your file? Do you want to wait today?
Yeah, is there a time that I won't wait now, but I'll come back at a specific time. Is there a time that I could see her or get the copy of it?
Well, I will tell her, I don't know what time she's going to be back from court today. I will certainly tell her to make a copy of the file and have it made available for you. We can leave it here with reception, so, I don't know, meeting with her again.
I would like to get back on court.
I don't think that's going to happen. Because you've already been relieved on the case. And I think that it seems that there's some contention already now.
There really isn't, because I told her when she presented me with the indictment and the felony complaint in the BDF, I told her that I did. She said, if you have any problems with me, why don't you just release it? I said I wouldn't like to, because we can fix these issues. And she was the one that didn't want to fix it. Because at that point I wasn't arraigned on the indictment, so the issue that I was bringing to her attention could have been fixed if at the next court date, which was on the 10th, she could have just stated that, Your Honor, we would like to enter an oral motion to dismiss the case due to legal insufficiency on a felony complaint. And I have both case law. I don't know how deep I'm going to get into conversation today, but I have case law here that states that the court doesn't have jurisdiction on an insufficient felony complaint and has no right to take the case forward to indictment, only if and they can only do that and arraign the defendant if a plea of guilty is entered. Because I told you I had stopped the arraignment before the second arraignment.
These are all matters that you should discuss with your new attorney.
Yeah, but I'd like Rebecca Gregory to look at that.
That's not going to happen.
I didn't do anything wrong.
I'm not
And
suggesting that you
she's
do, but
running.
you're looking
She's
at,
running from
you're
the
looking
issues
at
that
that
I'm
this
bringing
is
to her.
as a punishment. I
It
mean,
is a punishment because her leaving and not assisting me, she left me high and dry. And she
You
had
assigned another attorney.
no, before that, her stating that she didn't want to be on the case anymore just because I was telling her the same things that I told you here. Not with curse words, not with anger, not with anything disrespectful to her person, her character, her occupation, just regularly stating the fact as I just did today. She said, and I told you, she said, if you're having all these issues, why don't you just release me? And I said, I don't want to, because these are things that can be fixed, and it's not amounting to ineffective assistance as of yet. The Strickland standard hasn't been met yet. So as opposed to you leaving me high and dry, which she did, I'd like for you to stay on and remedy these issues, which could have been remedied, but she chose to run.
I can't speak to exactly what happened because I wasn't there, and I don't know exactly what happened, but, I don't know. I don't know if it's that the attorney-client communication has broken down to such that there was none.
It really wasn't.
Something happened that
I just was bringing up these issues.
No, it doesn't need to be that, but I'm saying something happened that
On
the
her
court
end.
saw fit to.
On her end,
Okay.
because he said that I didn't get the case dismissed at first. He ran it. He came to the office and left a legal notice. I did leave a legal notice, just stating the things that I wanted her as an agent to carry out on my behalf. But I know you guys say that a client has a right to testify, plead not guilty, and all these three things. Out of the multitude of issues in a criminal case, a client only has 3 options. That sounds like slavery. And I wanted to address her.
Okay, but when you have an attorney-client relationship, she's not,
She's a fiduciary agent.
yes, but she's not, but it doesn't, as you know, by doing the research that you've done, she doesn't have to do everything that you want her to do for your case, just because she's your fiduciary agent.
Why wouldn't she? If it's an insufficient felony complaint that she and I. That's your issue, and she may, I don't know, she may have issues, she may have reasons, I don't know. We're now having sort of a philosophical, And we should. I know you guys are not, you're not acting as a woman right now, you're an agent. I know nothing spiritual, nothing philosophical enters into this. It's just hard facts which are not truthful, but that's what can be proven. And slavery, if you're searching for what do you call that? Capital discrimination maximum, like just your civil death taking place. And you only have 3 options to engage in that out of everything, especially if you're innocent like me, being framed. Like I'm really being, this is a real injustice at the moment.
okay, but I would say, and again, we've now moved from the legal to the philosophical, but what I would say this to you, I'm trying to say it in a way that is not disrespectful to Ms. Gregory or to you. I think that Ms. Gregory is, again, I keep saying, I think she's an excellent attorney. And it certainly seems to me that you are a very intelligent man who knows, you've researched your case. It seems that you are very well aware of your rights and what you need to do. Sometimes, 2 people who are right and 2 people who are very well informed can't work well together.
Wait a minute. Wait a minute. Wait, first of all, you're not going to speed past that like you didn't just say what you just said.
2 people who are right and 2 people who are very well informed can't work well together. And that just may have been the same situation with you.
That's a very, very bad predicament for both of us to be in.
It may be, but that may be because I'm talking to you and you seem to be, again, I'm not having any problems communicating with you. I'm having what I think to be a very lovely discussion with you. I have lovely discussions with Ms. Gregory.
She was very nice. She was very nice.
So,
it's just at the point in time when when the disc wasn't working. I couldn't understand because, as I told you, with the 13 false arrests, every single time that I either had video evidence or that there was cameras in the area, they were always deleted. They were never presented, or the police never had the technology. So
I understand that things have happened to you in the past, but I don't know who was representing you in the past.
no, but she said an
Well,
IT
I
guy.
don't, well, that's my point. I mean, you can't, if you met me 2 minutes ago, for all you know, I could be the worst person in the world, and you would have no reason to trust the word that comes out of my mouth, because you don't know me. And you didn't know her at that time, and you don't know the IT guy, so you in reality, because of your experiences in the past, you could say, there's some guy out there who's gonna screw me, who's gonna take this information that I have, and is gonna really mess it up, who's gonna put it in the computer, and who's gonna delete everything, who's gonna do whatever. And from your past experiences, that may have been a valid point of view. However, Ms. Gregory, who again, has never had any dealings with you that I know of anyway, would have no reason to do that to you. So you came at it from your whole life experiences saying, now I have another situation where this is happening to me, I can't believe this is what's going on in my life, this is the 14th time that this is happening to me, this is ridiculous. Ms. Gregory is saying, hey, I'm trying to help this guy, I'm doing everything that I can, sometimes things happen. You know, sometimes cell phones break, sometimes lights go out, sometimes computer things happen. You know.
Can I give you guys a bit of advice regarding evidence that's actually so crucial to defendants proving their innocence? Please try not to put video evidence on disc. They can break. They're very flimsy.
Sure, I'm always happy to take advice that's going to help my clients. How would you suggest to do
A
it?
thumb drive is always best.
Like
because,
a, what are those called?
portable thumb drive. It's like that, like 2 inches.
No, not thumb drive. What are they called? The flash drive.
Yeah, flash drives, exactly. So
But I'm so tech non-savvy.
Yeah.
How would you transfer what you had, because you were giving a drive, right? How would you transfer what you had to that?
On a computer,
See, I'm not tech savvy, so I don't know.
You drag and drop, you load it on the flash drive, and as opposed to the DA saying that we don't have a CD burner or we don't have a drive that can play the CD, every computer has a USB port.
Okay.
So, thank you very much for your time.
Listen, I'm sorry, and again, as I said,
Yes.
Gregory happens to be a great attorney, and I'm sorry it didn't work out. But I will definitely make sure that the file is left here for you, okay?
Is there a specific time when I can come back? Or when that would be ready?
Well, I would say today is Thursday. I would say probably, because she's probably gonna have to order it, I would say Monday. The last time is always to come, I tell my clients when they want to see me to come between 1:15 and 2:15, because I'm here for lunch. So, doing that?
Yes.
But I would give her a call, or me, my name is Dorothy, just give me a call, and see if one of us are here to give it to you, okay?
I appreciate the time.
No problem, no problem. Sorry that you had all these problems.
Yeah, trying.
All right, you take care.